Welcome back. In this segment, we're going to talk about how courts make decisions, and I'm going to introduce two terms that are critical to that decision-making process, but that you might not be familiar with: stare decisis and precedent. Recall that courts have two functions. They evaluate and interpret the Constitution and statutes, and they develop and apply the common law. For both functions, the court relies on and is guided by the principle of stare decisis, a Latin term that means to stand by the thing decided and not disturb the calm. As applied, this principle means that courts try not to flip-flop from one decision to the next in order to provide some stability and predictability to their decisions. Why do courts apply the principle of stare decisis? There are several reasons. The first is fairness. As a society, we want litigants who experience similar factual situations to have similar results. The second is predictability. Future litigants deserve to know that their situation will be judged by the same rules and standards that have been developed in previous cases, and that those rules and standards won't change on a dime. The last benefit is efficiency. Stare decisis means courts need not revisit legal issues or rules that have already been determined by previous courts, and can focus instead on new and novel issues before the court. Stare decisis, in turn, relies on precedent. Precedent is a rule of law that is established in one case that governs the decision of future cases. It means, in essence, that if an appellate court makes a rule of law, the lower courts are bound by that decision. It also means that higher courts are generally bound by their own previous decisions, with some exceptions. Let me give you an example of how that works. An appellate court has ruled that saying to someone, "You stink to me," is not a tort, and the Supreme Court has not spoken on the issue. If a trial court is trying to determine whether the statement, "You're a jerk," is a tort, it will very likely be bound by that appellate court opinion, because the factual situations are so similar, and have to rule that it is not a tort. There are three factors to take into consideration when determining if precedent applies: the structure of the court, whether the part of the court decision in question is the holding, and whether the facts of the case are similar such that the holding applies. Let me take each in turn. The first is the structure of the court. Only certain courts bind the decisions of others. Any precedent that isn't binding on a lower court is called persuasive. Using the Eastern District of Michigan as an example, you'll see that the Eastern District of Michigan is only bound by the decisions of the courts directly above it in the federal hierarchy. So, as you can see on the screen, the Eastern District of Michigan is bound by the Sixth Circuit decisions and, of course, also bound by the Supreme Court decisions. The Eastern District of Michigan, however, is not bound by decisions from the Western District of Michigan, nor is it bound by decisions of, say, the Seventh Circuit. If the Sixth Circuit has not spoken on a particular issue, the Eastern District of Michigan might look to the Seventh Circuit for guidance. It might even be persuaded by the Seventh Circuit's decision and its reasoning. But it's not bound by that decision, and it could ultimately make a decision that's contrary to the Seventh Circuit's decision. The appellate circuits, in turn, are bound only by the Supreme Court. However, they're not bound by their sister circuit decisions. So the Sixth Circuit is free to disagree with the Seventh Circuit opinion. In a system like Michigan, where there's a single court of appeals, the same principle applies. All trial courts in the Michigan Circuit are bound by the Unified Michigan Court of Appeals decisions. The Court of Appeals is in turn bound by the Michigan Supreme Court decisions. Appellate courts in both systems are also generally bound by their own prior decisions. For example, federal circuit courts generally make decisions in panels of 3 judges at a time. However, if a federal circuit court wants to overrule a prior decision that one of its panels made, it generally has to call together all of its judges to hear the case, what is known as en banc. The same stare decisis principle also applies to the U.S. Supreme Court. However, the Supreme Court has the ability to overrule its own precedent without taking the extra step the circuit courts must take, because all of the Supreme Court justices participate in hearing all of the court's cases. The Supreme Court has listed some of the factors it takes into account when determining whether to overrule its own precedent. These include the age of the previous decision, how much the parties and the public have come to rely on that decision, whether that previous decision was well-reasoned, and whether experience has pointed to the precedent's shortcomings, the workability of the decision. Although the court has identified these as factors, it is important to note that the court hasn't always applied these factors consistently. Note that the principle of stare decisis is just that, a principle. It isn't a hard and fast rule that the court is strictly bound by. And this is why you will see the court sometimes overturning prior precedent, even where the decision may appear to satisfy the conditions for maintaining it. You'll learn more about this and likely discuss cases that have been affected by this principle in your constitutional law class. A somewhat trickier situation is involved when a state court is deciding a federal issue. In that situation, the state court is bound only by the U.S. Supreme Court decisions and no other decisions of the federal court system. Similarly, where a federal court is trying to decide a state issue, as it might, for example, when there's diversity jurisdiction, it is bound only by the decisions of the state Supreme Court. Knowing which courts bind the decisions of others, however, is only part of the equation. The second factor to take into consideration when determining if precedent applies is whether the part of the decision to be applied is the holding of the case. Even if a court is structurally bound by the decision of a previous court, it's only bound by the holding of that case, not by the dicta. Holding is defined as the decision the court makes plus the operative facts. Those are the facts that make a difference to the court's reasoning. Dicta is everything else the court says. And it could include, for example, speculation by the court as to how its decision might be different if it were faced with a different set of facts. The distinction may sound simple and easy to identify, but I want to be clear that it is often anything but. Courts don't often make the distinction between the two very clear in their opinions, so lawyers regularly argue about whether something a court said is holding or dicta. As you begin to read cases and are asked in class to state the holding of a case, don't worry if you get it wrong or include some dicta. Eventually you'll get better at knowing the difference. The final factor to take into consideration when determining if precedent applies is the similarity of the facts and the legal issue. A court is only bound by a previous decision if the legal issue being considered is the same and the facts are similar. Let's go back to the example of the trial court trying to determine if you're a jerk is a tort. As I told you, it's very likely bound to follow the decision of the appellate court that has held that you stink to me is not a tort. The insults there are similar in nature, and therefore it's likely that that's binding precedent. But what if you have a situation now where the trial court is trying to determine if the statement, "you're a drunk and a thief," is a tort? Is that similar enough to "you stink to me"? Or are there substantive, important differences between the quality of those two insults, such that the result might not necessarily be the same? Like determining the holding of a case, determining whether the two cases are factually similar, such that the rule developed in one should apply to the next, is a huge part of what lawyers do every day, and what you're going to be doing this year in your 1L classes, including in legal practice.